Thank you, everybody, for joining us this morning. I see a few familiar names here attending live, and I'm glad you've joined me this morning to talk about an important topic of special needs trust administration. I have a disclaimer. As many of you know, I am an attorney licensed in the state of Arizona. However, the information I'm giving today should not be taken as your legal advice. I'm going to encourage throughout the presentation that you work with an attorney who is competent in this area to get specific legal advice as it relates to your situation or circumstance. So with that, I know some of you may just be getting to know me or my practice. So briefly wanted to give you a little bit of my personal background. I grew up in the Midwest, Galena, Illinois, very small town, but moved to Arizona 23 years ago to go to ASU and stayed here since then. I went to law school at U of A, and I have been practicing for the last 16 years, specifically in the area of estate planning, special needs planning, and elder law. So I'm a member of the Special Needs Alliance, the Academy of Special Needs Planners, National Academy of Elder Law Attorneys, all of these acronyms, but they're all wonderful organizations, and they're great organizations if you yourself are looking to find an attorney who is well versed in the area of special needs trust. That's where I would start. So with that, let's go over the agenda for today. I want to get right into things. I am going to briefly review government benefits. Of course, I have and others have done deep dives into those sections specifically, and so today is just a very cursory review so that we're all on the same page as we start to talk about special needs trust administration. I'm also going to quickly review the different types of special needs trusts really broadly. So if you need to do or want to do any more specific deep dives there, again, other videos available for you to learn more about those. Then we're going to spend quite a bit of time talking about trustee duties, what that looks like, whether you're the trustee or you've nominated somebody in your estate plan to be the trustee someday. We'll go over that. And then, like I said, we'll address any questions. So please feel free to ask, and we'll get started. So the reason I want to go over benefits quickly before we start talking about special needs administration is that benefits are essentially the name of the game. The reason we do a special needs trust and therefore administer a special needs trust is to prevent terminating benefits that are subject to different restrictions. And so when we think about the benefit of having a special needs trust, we're indicating that we want that beneficiary to remain eligible for different services. So when we start talking about Social Security, we all know there's many different types of Social Security. Most of us are familiar with retirement benefits. Of course, we also know Social Security disability insurance. What that means is that with Social Security disability insurance, when we get a paycheck and a portion of that goes off with Social Security, we've in essence purchased some Social Security disability insurance. So SSDI is not a means tested benefit. To qualify for Social Security disability insurance, you need to review that you've paid in enough to Social Security, and then the amount of Social Security disability or SSDI you get is dependent on how much you've contributed. SSDI, therefore, is tied to Medicare and a few other things, but it isn't going to consider what type of assets you have, how much you have in your bank accounts, things like that. On the other hand, SSI, supplemental security income, does consider what assets an individual has. And so currently an individual is only allowed to have up to $2,000 in countable resources. What's that mean? It's any bank accounts, it's any sort of cash, it is life insurance, cash value, it is minors accounts, it is all sorts of things. And so with SSI, it's really tricky to maintain eligibility if we have an instance where somebody comes into money, whether that's as a result of a settlement or perhaps it's a result of an inheritance. SSI is very, very tricky. And so an individual receiving SSI needs to be very, very mindful. And so a lot of times individuals with SSI benefits have special needs trusts. And so I've highlighted that because here in this lineup, SSI is going to be the one today that we're really talking about protecting. Now, disabled adult child benefits is this type of Social Security benefit, which we kind of not transpose, but what we're looking at is when somebody who has been determined eligible for SSI or Social Security prior to age 22, their parent then later takes Social Security benefits, whether that's retirement benefits, SSDI benefits, or they pass away. An individual who's a disabled adult child is now going to start receiving benefits based on their parents' payment into the system. And so it switches from SSI being that means tested back to a more secure type, similar to Social Security disability insurance. And it's based particularly on the inability to work. And then survivor's benefits. So we talk about that sometimes when somebody passes away. But again, Social Security, for today's purposes, SSI is a real tricky one that we want to be mindful of. Moving very quickly on, we're going to talk a little bit about DDD. DDD, as many of you know, is Division of Developmental Disabilities here in Arizona. It's a list of the different diagnoses that allow for eligibility for DDD. Now, DDD is services, but it's really the coordination of those services, because without ALTEX, there are no services that are funded by the state. So ALTEX is Arizona Long-Term Care System. Again, I kind of highlighted it because just like SSI, when we're thinking about protecting the benefits that DDD coordinates, what we're really wanting to protect is eligibility for ALTEX through Medicaid. So very, very important. You need to be mindful of that. Again, an individual on ALTEX is only allowed to have $2,000 in accountable resources. So we really need to be mindful of the type of special needs trust we're having and its interplay with Medicaid in that way. Of course, to be eligible for ALTEX, you need to meet resource criteria, which is where the trust comes into place. You also need to meet income criteria, which income also, we have a special treatment trust that can be used for what's called an income only trust or a Miller trust. And we want to make sure we're eligible there. Now, access is also a very common benefit. Access you can be eligible for a whole host of number of ways. And so we just need to understand how that interplays with your particular benefits. So that is by far the fastest I've ever tried to review government benefits, but I encourage you to go do a deep dive, because one of the things you're going to see is when we start talking about administering special needs trusts, that's super important to really understand the interplay. The other thing is there's housing benefits, there's veterans benefits, there's all sorts of things. So we really need to know all of that. But for today's purpose, at a high level, we're going to talk a lot about ALTEX and SSI and how those two interplay with special needs trusts and how the administration can impact those benefits. So again, quickly, for review of special needs trust, let's talk about this. Because today, as we're talking about administration of special needs trust, we do need to be mindful about what type of special needs trust we're administering. The term special needs trust is kind of a generic term used to cover a whole host of different tools. Primarily, we're thinking about what's called a third party and a first party or self-settled special needs trust. So you can see the two categories here on the screen. We've got third-party trust. There's two different types, a standalone trust and subtrust. And then down towards the bottom, we've got a self-settled or a first-party special needs trust. Very different types of trusts. Now, the term special treatment trust is a term that Arizona uses when we're talking about ALTEX, and we can call them supplemental needs trusts. We could talk about pooled trusts. You can see if by the end of this you don't take for granted how simple trust administration can be compared to special needs trust administration, I haven't probably done my job. But we just need to know that there's differences, and we need to know that our trustee, whether that's us now or our trustee in the future, can figure out exactly what type of trust they're administering. So when I look at special needs trust, there's two big questions. Where is the money coming from and what are we protecting? So if you see this diagram here on the screen and you've come to see me in person, you've probably seen me draw some pictures for you, and this tends to be what we go through. But when we're figuring out at first glance what type of special needs trust are we talking about, we're going to consider where is the money coming from. Now, in the case we're talking about money that's been inherited and the plan was set up correctly, we're hopefully looking at a third-party special needs, supplemental needs what have you. A third-party trust means that the funds never actually went directly to the beneficiary in terms of ownership. So mom and dad set up an estate plan and they said an interest that was going to pass to their child who receives SSI benefits, for example, doesn't go directly to that beneficiary and instead flows through to the third-party trust. Money that legally belongs to the person receiving benefits needs to go into a first-party special needs trust or a self-settled special needs trust in order for it to be protected. It cannot go into the third party. So first-party special needs trusts tend to be the ones that are a bit trickier, and we're going to cover some of that. So first-party special needs trusts, money has come in. The trust must be irrevocable. It has to be established and funded before the age of 65. It has to be funded by assets belonging to that beneficiary. So self-settled, those assets belong to them. Sometimes there is often, depending on the benefits, the beneficiary is receiving a lot more oversight. And sometimes there's oversight by the court for this nature. That will depend on the capacity of the beneficiary. Of course, somebody may be receiving all-tax or SSI benefits because of a physical disability, which does not impact their ability to set up or create a special needs trust. In that case, sometimes the court doesn't have to get involved in terms of conservatorship. And the big thing is that with a first-party special needs trust, at the end of the administration, commonly when the trust is terminated as a result of the beneficiary's death, the state can make a claim to the assets. And so that's really, really important because once they can make a claim, they by default have a lot more rules we have to follow in terms of administration of a first party special needs trust. So like I said, first party special needs trusts tend to come up primarily in settings like a settlement. So a lawsuit settlement because of an injury, a lawsuit settlement just because of a fender bender. Sometimes first party special needs trusts come into play because somebody becomes disabled or has a disabling event later in life before they're age 65 and they need to protect assets that they already have or they already own. And then sometimes, unfortunately, first party special needs trusts do need to be created when somebody hasn't done proper estate planning. So we don't have a lot of control over when or how a first party special needs trust gets set up because a lot of times it's just the tool we need in that circumstance. The place we do have some control is that if we are planning in advance for our own death, then we need to make sure that we've got an estate plan that sets up a third-party trust. And so third-party, as I mentioned, means it's going to be funded with assets of anybody other than the individual receiving those public programs. So created and funded by a loved one on behalf of a beneficiary with special needs for receiving benefits, funded by assets not belonging to the beneficiary. So grandma's life insurance goes into a third-party trust, mom and dad's interest in their home, the bank accounts, investments, what have you. And the good thing is that the trust maker can designate when the trust terminates otherwise for that primary beneficiary, then what happens for the remainder beneficiary. So it's not the state of Arizona, instead it's passing to other family members, etc. So very quickly, I just want to review this to make sure I'm using some clear examples, but let's say we have a beneficiary. His name is Adam, and Adam is receiving SSI benefits. That means he has not paid into the Social Security system enough to be eligible for SSDI, and he has not yet rolled onto disabled adult child benefits. In 2023, he's getting approximately $914 a month, and that SSI is very sensitive to Adam having any other resources. He must have less than $2,000 in his own name. Adam is also eligible for DDD because of the diagnosis that he has. Because of that, DDD is coordinating support, and those support coordinators are providing benefits that are funded by all-tax. So we know this is very important for Adam that he continue to receive his income, his insurance, and his respite and have hours, his attendant care, his speech, his PT, his OT, all of those different things, super important for Adam. And so in example number one, Adam's grandma doesn't understand the nature of Adam's situation. And so she thinks she's being generous, but she sets up a life insurance policy and she names Adam individually as the beneficiary of that life insurance policy. Grandma then passes away, and Adam's parents look at the beneficiary designation and say, oh no, she's named Adam. Well, Adam now has ownership interest in this life insurance policy. And if we say it's $50,000, for example, they're going to say, okay, well, Adam now has ownership, but because of Adam's diagnosis, he's not able to manage or protect these assets. He wouldn't understand what to do with it. So first of all, in this case, they're probably going to have to go to court to establish a conservatorship, or at least ask for single transaction authority so that the court can make sure that that $50,000 can be appropriately protected. So in this case, an ABLE account is not appropriate because we have a lot more than $17,000. We need to protect it because we need to keep Adam's benefits on SSI and Altex. And so we're going to have to get the court to approve the transfer of that $50,000 into a first party self-settled special needs trust. Adam's going to be the beneficiary of that trust for the remainder of his life, but let's say he passes then 10 years later and there's $30,000 remaining in that trust. That trust is going to say that HMS or Altex through the state is going to have a right to have a claim to those monies. And so because Adam's been receiving Altex for a long, long time, they're going to almost certainly receive the remaining $30,000 out of that trust. In addition, that first party special needs trust, that trustee, the person, anybody other than Adam, who's been appropriately managing that, is going to have had a lot of administrative tasks. Now, on the other hand, Adam's parents, having gone through this and realizing how unhelpful it was for grandma to leave that money, they're going to sit down and talk to an attorney about setting up a third party trust. And what that means is Adam's parents are going to set up a will or a trust that says when they pass away, instead of Adam being the beneficiary, they're going to say his portion of their estate is going to flow directly into a third party trust. And they decide it's kind of nice that they want to start saving now. So they're going to set up a standalone trust and they're going to be the trustees and they're going to administer that. But it's also going to say that when Adam passes away, if there's money left in that third party trust, then it's going to go back to his siblings or his nieces or nephews. So hopefully that was a helpful illustration to describe the primary different types. And if we've met before, you've heard all of this, but it is always good to review because it's so important we know exactly what type of trust we're talking about. And it's so unfortunate that our industry has failed to come up with terminology that is used to talk about different things without having some overlap and confusion there. So you'll hear me point out first party and third party today as we go through administration. So we're finally there. Let's start talking about special needs trust administration. I kind of did lions and tigers and bears. Oh my, I don't know why that was in my head, but taxes and investments and oh my, so many more things. So that's what we're going to try to cover today is when somebody, whether that's you are acting as a trustee or you're trying to figure out someday when you're not able to be trustee who you want to name or nominate, we want a sense of what that trustee is going to be responsible for. And this is an important part of planning. And when I'm working with clients, we're going to dig into this to see who's appropriate. We're not going to put our, the first person who comes across our mind who maybe we saw at breakfast because it's a big job. It's a big ask. It's a commitment. And as you're going to learn today, there's a lot of responsibilities. And so how do we structure not only your estate plan, or in some cases that first party trust in a way that we've got the right person or professional serving as trustee, but also how can we help them administer the trust or know what they need to do in administering the trust so that it isn't something that they find themselves in hot water or inadvertently impacting the benefits that our most important beneficiary is going to be receiving. So trustees' duties. A lot of times, I hope in my personal life, and I think a lot of us hope, there's just going to be a straight path forward, right? We're going to have a trustee get appointed. They're going to take over, they're going to collect everything, they're going to disclose it to the agencies, they're going to do accounting, they're going to have a good investment plan, they're going to file taxes, and then the trust is going to be terminated. Unfortunately, the reality is all of these things are happening in conjunction. Of course, they're going to have to collect and fund and get appointed as trustee. That's just the start. What you're going to find as a trustee, whether that's you or the person who takes over, there's always going to be changes. Social Security and Medicaid are going to change their rules. I could tell you the rules today. That's not going to be the rules tomorrow. Maybe tomorrow, because tomorrow's a weekend, but it's not going to be the rules a year from now, a decade from now, all of that. So really, we need a trustee that can keep up with and balance all these different pieces. So annually, they're going to have accounting obligations, if not more frequently. They're always going to be needing to monitor the investment strategy. They're annually going to have to file taxes. They're going to at least annually have to do some disclosures to government benefits. So that's going to keep happening over and over. There's always going to be changes. The beneficiary is always going to need distributions. Those distributions are going to change. And then they have these duties as a trustee that they need to stay on top of. So they need to make sure they're remaining impartial, not only to the current beneficiary, but the remainder beneficiary, whether that's the state of Arizona or if it's other family members or charities. They're also going to have their broad fiduciary duty, do a little bit, and they're going to need to make sure they don't have any inherent conflict of interest, that they're not self-dealing, especially if this trustee is also the guardian, for example. So you can start to understand the true role that this is and how it's so important that we create the right individual. I said create, I wish. Maybe we can create the right individual someday. Appoint or nominate the right successor trustee. So we have not only the good discretion, right? That's what we're really wanting them to step in, but also that they can take on this balancing act for all of these different pieces. So with that, we're going to have to start somewhere. So let's start thinking about all the different things the trustee is going to have to do. So first of all, I'd always encourage them or you to review the trust document. A trust is typically governed by a written legal document. It may have amendments, it may have changes, but the trust document itself is the first place to start. Let's look at the trust. Let's make sure we understand the very basic of the trust. That's going to help us figure out if it's a first party or a third party. It's going to help us figure out if it was drafted correctly. We're also going to want to get to know the beneficiary. So perhaps it's a relative. Well, that relative may be a cousin. They may have known this beneficiary every summer. They saw him at a barbecue. They got to have Christmas holidays with them. But really, what is the day-to-day needs of that beneficiary? How does that beneficiary communicate? How is the trustee going to interact with them to make sure that the trust is doing its best for that beneficiary? And importantly, they're going to need to know all of the government benefits that that beneficiary is on. So we briefly went over some very few, but it's common that a beneficiary of a special needs trust is going to be receiving any number of services, and they themselves may not understand exactly the nature of the type of benefit they're on. They may have been receiving SSI. Now, because perhaps their parent passed away, they may now be receiving disabled adult child benefits. They don't necessarily understand the exact type of service they're receiving or benefit they're receiving because it changes frequently. Our government agencies aren't exactly perfect at describing that for beneficiaries. So it's a puzzle, and you need to figure out exactly what they are receiving and how is this trust and the funding of it and the disclosure of it going to potentially impact that. We need to understand the trust assets, what's currently in the trust, what do we need to go collect and put in the trust, what's ultimately going to be in there, and we need to recognize any deadlines. So as a trustee, you have deadlines as it relates to notification to government agencies, notification to beneficiaries. You also probably have some tax deadlines. You may have some deadlines depending on if one of the trust assets is a retirement account, gathering all of this information to get started. We're going to continue on and where to get started in terms of reading the trust again. We're never going to stop reviewing the trust. As a practicing attorney, it's practicing. Just like as acting as a trustee, you're always going to be referring to not only the trust document, but the rules and the law and any other sort of information. I'm highly going to encourage any trustee of a special needs trust to consult with a special needs attorney. Most likely, you're going to want to have that attorney represent you on some capacity. It may just be that it's a very straightforward and simple trust, and that the trustee doesn't require ongoing representation. However, there's a lot of on-ramping for getting this trust up and running and making sure that it's set up correctly so that they have the right pieces in place. Now, I highlighted special needs attorney, and that is just because there are a lot of trusts. Special needs trusts are very unique. And so if we're looking for an attorney to represent us, we do need to make sure that they have specific experience and understanding of special needs trusts and the benefits element. There are a lot of attorneys who do trust administration, but they're not typically looking at special needs trusts. So it's just important to make sure that you've got the right fit. We probably also want them to hire an accountant, almost certainly. Probably also an investment advisor, making sure they've got professional investment assistants. And some cases that trustee is going to want to, if they're an individual, hire a professional trustee to assist. And perhaps the terms of the trust are going to allow them to appoint them as a co-trustee, or perhaps they're going to hire them in their agency capacity. But these are just places to get started. So what we really understand or want to understand too is what is the responsibility of the trustee. And the responsibilities of the trustee hopefully are laid out in the trust document, but also you need to understand that the laws are going to govern their role. And so a couple big things, this is not all of them, but Arizona does have a trust code. You can find it in our revised statutes. I encourage you to go read it. Very exciting stuff. Some of the big ones, the first one is impartiality. So a lot of times trusts will have more than one beneficiary. Now in your special needs trust, in the example I gave, for example, Adam is going to be the primary beneficiary. But when Adam passes away, there are remainder beneficiaries. And so the law is going to dictate what responsibilities we have not only to Adam, but also to the remainder beneficiaries, whether that's the state of Arizona, whether that's his siblings, whether that's charities. We really need to understand that. And the trustee has to have the ability to act impartially. They need to be able to make distributions and management decisions based on their rules. We also need the trustee to take on their administration or their duty to administer the trust. So they actually have to do the job. And as we go through this, you're learning how big of a role and responsibility this is. And so we need to make sure that they understand that they need to take the job on, but that it's an ongoing process. They need to be able to look at all the different elements and make sure in good faith they're taking all of the actions we've discussed. We also need a duty of loyalty. So that means avoiding self-dealing and a conflict of interest. So for example, if the trustee is also a guardian, does the trustee have certain considerations to bear in mind when they're thinking of making distributions from the trust for a family vacation that the guardian gets to go on or benefit from? How about when a vehicle is needed? How about housing decisions? There's a lot of different potential conflicts of interest, and we just want to make sure that the trustee is acting in a way that they're not self-dealing and that they're cognizant of those conflicts of interest. And if appropriate, they're either bringing in an independent trustee to review or coordinating with a trust protector or another party to make sure that they're not doing anything that goes against this duty or obligation. Trustee also, like I said, can hire an accountant, an investment advisor, or an attorney, and so they may delegate some of their parts of their role, but they do need to make sure that they're doing that in a way that they're delegating it to somebody appropriate, so that they're not just hiring an accountant who advertised on Facebook that they could do a tax return without understanding all the nature of the special needs trust tax return. They also have some duties as it relates to record keeping. That's going to be a broad one here because we're going to be, again, potentially keeping records not only for the beneficiaries as the standard with most trusts, but also government agencies that may be asking. And they have a duty to inform and report. So these are each going to be duties that are specific to the unique situation, and we really want to make sure the trustee understands all of that. We also in Arizona have the prudent investor rule. And so I kind of inserted here some of the language that comes from the statute, but it's an obligation to make sure that the investments of the trust are appropriate. And understanding that usually means working with a professional who understands it, because you want to make sure that even though it seems like a great investment to take some of this trust money and invest it into a friend or family's new restaurant business, that trustee has a certain obligation and rules they need to follow in terms of that investment on somebody else's behalf, the beneficiaries. We want to make sure they're not overly conservative in the sense that they're losing out on interest or dividends if they're held entirely in cash, or they're not overly aggressive in terms of putting everything in highly volatile or risky investments. And so that prudent investor rule is really important. And a lot of times we're going to want to encourage them to work with a professional advisor who can help them understand that investor rule, appropriately diversify, appropriately have access to trust assets or resources that may be needed by the beneficiary when the time's appropriate, and reduce any risk that unnecessarily needs to be taken when it comes to that. Part of this is also if you are in the role of trust creator rather than trustee, and you've established a trust, you also want to make sure that your philosophies have been shared in terms of your intentions of the trustee. And so it's important to review the trust document, make sure you're comfortable with the level of authority they have. Now, with all of that, one of the first things to kind of start talking a little bit more specifically about is the disclosure of the trust and trust funding. What does that mean? So the disclosure of the trust is going to be important to a couple of different people. So first of all, the beneficiaries. Under the terms of the trust or under the state law, the trustee has certain obligations to disclose to certain beneficiaries, perhaps the establishment of the trust, the funding of the trust, all sorts of things. That's going to be really unique, and we're going to need to know exactly what rules we have to follow. This also could create a deadline. So when you step in as a trustee or when your trustee steps in, they need to know that they don't have an unlimited amount of time. If the individual is receiving services through Medicaid in the state of Arizona, that's Altex for long-term care, we need to make sure that the trust disclosure and funding has happened promptly, very promptly, so that they can step in and disclose everything to Altex. We're going to want to make sure they do that. Altex is also going to require, depending on what type of trust it is, additional documentation. So if it's a first-party trust, for example, they're going to require anticipated disbursements. What's that? It's a budget, essentially, that gets approved for distributions. You're really going to need to understand what gets disclosed and what rules you need to follow. And so if there are Altex benefits and it is a first-party trust, there's going to be a lot. You need to anticipate that. Social Security Administration, again, we're going to need to know and understand what type of Social Security the beneficiary is on, but depending on that, again, the funding and disclosure is going to be important. Some at a higher level, some at a lower level. Who else needs to know about it? Is there housing benefits? Does the VA need a copy? Does the court need a copy? Does the individual's guardian or conservator need a copy? And then we're going to want proof of disclosure. So you want to make sure that when somebody says 5 years from now, hey, you never told me about this. If you did, you want to be able to say, here's a copy of the certified mail I sent you. Or here, this was stamped received when I dropped it off at Social Security. Or Altex, I faxed it, I emailed it, I dropped it off, and I mailed it. And here's proof of all four. You're going to want proof of that. And so in a digital age, there are ways to do that digitally, but most importantly, if you are dropping it off or putting it in the mail, we're going to want proof that that actually happened through return receipt or stamped confirmation. Accounting and auditing, again, understanding your obligations. So the most important thing is to really understand who's going to be looking at this, and that's going to come back to what type of benefits are on here. That being said, the beneficiary or the beneficiary's representative, they don't have the capacity to do so, probably is entitled to accountings, and we really want to make sure that we're doing that so that we can make sure the appropriate beneficiaries are getting accountings. That's going to limit the trustee's liability if done properly. The trust may have what's called a trust protector, another individual or a corporate entity, which is going to be somebody who's entitled to accountings or has the ability to review books. The court may have supervision or oversight of the trust. That tends to be more common in terms of a first-party special needs trust. And then agencies, who's going to be asking on an annual basis. who's going to ask only if you get drawn out of a hat once every decade? Understanding those obligations. There's going to be a difference between what's required and what's good practice. And that's going to be unique to the trust administration that in this case, it's going to be different for everybody. But often we're going to want to do it in a way that is appropriate with good practice to limit the trustee's liabilities. We're going to request release and waivers. And there's inconsistencies. So what might be the rule as it relates to Social Security today may be an entirely different rule than today. Taxes. So I am not an accountant, and this is not tax advice, but taxes are a part of life for us as individuals, as well as for trusts. And taxes are going to be a really, really important thing for a trustee to make sure they have a good grasp and understanding of. So what you're going to want to do is hire who has a good understanding and grasp of special needs trusts and accounting. This is going to be really important for a lot of reasons. One, of course, is the IRS and just making sure we follow and understand our duties and obligations. But two is because depending on how we report income, whether that income is reported as the trust income, you know what kind of trust it is, it's going to be a tax at very different levels. Or if we're going to pass income through to a beneficiary, how is that income going to impact that person's receipt of benefits? So for example, if Adam in our earlier matter or example is receiving housing support and that income is going to be reflected on his tax return, or perhaps he's receiving SNAP benefits, sometimes known as food support. What is his reportable income is going to impact his ability to receive different benefits. And so, like I said from the beginning, understanding those benefits and how they are going to be impacted is super, super important. And that's going to come into play again with taxes. We also really need to understand the timing. So the trustee is going to need to understand what their obligations in terms of filing and extensions, things like that. And then retirement accounts, IRAs, 401ks, those types of things have very specific rules as it relates to taxes. And most of you are familiar with the term the Secure Act. And so you understand that how income or distributions from a retirement account get taxed are a very tricky piece. And special needs trusts in and of itself amplify that trickiness. And so working with a professional who really understands all those different elements is super important. Now, this tends to be one of the things we think about first and foremost, but we're finally getting to it. So distributions, that's a big part of the trustee's job, is making sure that the assets that are held in the trust are distributed to the beneficiary in a way that improves their quality of life, meets the terms of the trust, and really is helpful in all the ways that we want it to, and not helpful is minimized in terms of impacting these benefits. So again, we're going to look at the terms of the trust, we're going to look at the law, we're going to look at the benefits, and we're going to figure out what's allowed, what's appropriate, what's a good idea. We also might be looking at a letter of intent. So if the person who wrote the trust or funded the trust has put together a letter of their intention, talking about the beneficiary, what the beneficiary might need or like or want, and what are their intentions in terms of that discretion. So in some cases, the beneficiary may have a love of musicals, and it may say in that letter of intent that the trustee should buy first row annual season tickets down at Gamage and make sure that every show that comes into town, we've got the best seats. That may be very clear in the letter of intention. On the other hand, if the beneficiary is a sneakerhead and they need the newest Air Jordans or what have you, I don't know enough about tennis shoes to use some good examples, but there's all sorts of things that are unique. And so if you are currently in the role of a trustor or a trust maker, that letter of intent can be really helpful for that trustee when you're not there to be able to share those pieces. Now, again, we need to make sure we're understanding the impact of that distribution on benefits. I will point out SSI, like I said in the start, is very, very tricky. So we need to be careful about what's called in-kind support and maintenance. Because SSI, if the beneficiary is receiving SSI, is very tricky as it relates to anybody else, whether it's through a special needs trust or by an individual paying for food and shelter. So we just really need to understand that rule, because making distributions for those two items can reduce the amount of benefits that the beneficiary is getting from SSI. So we just need to be intentional and mindful about that. Sustainability of the trust is also important, that the trustee be able to make sure that the trust is going to be around. It's going to have some resources. So, you know, when it comes to making a distribution for a vehicle, it would be lovely to have a fully tricked out, modified Range Rover, for example. But if, you know, the assets of the trust will be greatly depleted because we've got this very fancy over the top vehicle, they need to reconsider that. And so the trustee needs to understand, based on the assets of the trust, how it's invested, its likely income, balancing that amongst the benefits. How can we make sure that the trust is sustainable? And sole benefit. So for example, that first party special needs trust and other types of special needs trusts sometimes need to be for the sole benefit of the beneficiary. Well, that can be interpreted very differently, but it's very strictly interpreted by Altex, for example, and by SSI. And so that means that if our beneficiary is residing in a household with 5 other members, meaning there's 6 in total, and the trust is going to be paying for a new refrigerator that all 6 homeowners own, perhaps you're only going to be able to make a distribution of 1/6 of that benefit. So just need to be very, very careful. And that again is going to be unique to written terms of the trust and what type of benefits the trust beneficiary is on, all sorts of things. So with that, I got through a lot of it, and I know I brought up a lot of topics. So I imagine there may be some questions. But what I want to share with you, like I shared before, is that I am going to send out following this, and I'll have it in the recording notes as well, a link to a trustee's guide. I also want to share with you some recommendations and some information that if you need to find a special needs attorney in your area, of course, we'd be happy to help you, but if you're somewhere else, or perhaps I'm retired in the Mediterranean, as I love to say, making sure you find a good resource, or your trustee has a good resource. Not seeing any questions. So go ahead and enter them there if you'd like. But with that, I think, you know, overall, here we go. Okay. Rita, you're muted. There you go. Do you have a question?
Hi, Emily. Do you want to say it, Katie?
Sure.
Katie has a question.
Hi, Katie. Good morning.
Morning. I'm, well,
Oh,
the person the trust is for, and I was just wondering what if I want to take money out of my trust, but my beneficiaries say no?
not the beneficiaries, but is it the trustee?
Yeah, the trustee, exactly.
Am I the beneficiary?
Yep. Yeah. So Katie, you're the beneficiary of the trust, and that's a great question, because it does come up that sometimes the trustees are in a tough position and they have to say no. Now, there's a lot of reasons why they might say no. They might say no because it might mean that you would end a very important benefit, and their job is to really explain and work with you to make sure that's clear on why they might be saying no. Now, they could be saying no because it might be something that the trust can't afford. On the other hand, I hope it's a rare circumstance, but they might be saying no for not a good reason. If they don't have a good reason, then it's really important to work with either the trust protector, if there is one, or the trustee to maybe see if the trustee is not a good fit. So from time to time, trustees have to resign or might be removed if they're saying no for a bad reason. But that's the hard part, you know. Trustees are going to have a lot of reasons, and if they have good reasons, we need to listen and take that into consideration, and then hopefully they can get creative with how they might be able to satisfy a need or figure out if we might be able to solve that need somewhere else. But unfortunately, a part of a trustee's job is from time to time to say no, but they have to be doing that for the right reason. And so you really need to understand why. So I know that's scary to think about a trustee saying no, but if they're saying no, you need to understand why. And if it's appropriate, we're going to have to get creative and figure out how we can get them to a yes, or change the request a little bit. And if it's a good reason, we're going to have to make sure we understand what that is. Does that help, Katie? I know it's not a firm
Yes,
answer,
thank
but okay, good. Rita, did
Thanks,
you have any other questions?
Nope. Thanks, Emily.
You're welcome. Good to chat with you guys. Okay.
You too.
Maria, I see you have a question and you're on mute. So there you go. If you want to unmute yourself. What's your question, Maria?
Hi, good morning. So I was wondering, I have parents that say they want to put away a portion of the monthly SSI check. Can that be done to add to the trust on a regular basis, monthly basis, or every few months where they can add a portion of the SSI check so that in the special needs trust further on, it can keep building, I guess is my question. Is
Sure.
that allowed?
Well, that's a tricky question. So let's work our way through it. If we're thinking about SSI,
Mhm.
that money comes into the individual. That is first party money. That's their money. And so if they're going to save it, they only have a couple options. They could save it by putting it into an ABLE account. Because the ABLE account, they're allowed to put their own money directly in, and money that goes into an ABLE account is not considered available so long as that's meets all of the other rules. So an ABLE account is a potential mechanism for an individual to save their own SSI. A first party potentially, but ABLE is going to work typically because with SSI, we're not going to reach that $17,000 threshold. On the other hand, you mentioned parents saving that SSI. So you can't put first party money directly into a third party money trust. Does that make sense?
Mm-hmm.
So sometimes parents will set up a third party trust. And sometimes, for example, that let's say Adam is paying his parents' rent. He is every month taking a portion of his rental or his SSI, and he's paying rent to stay in his parents' home. Now, what the parent does with that rental income is their own choice. If they want to set it aside and save it in that third party trust once it's theirs, that's fine. We need to be really, really careful if it's SSI money, if it's the individual saving their own, then we're kind of restricted to that ABLE account or first party. But if that individual is paying rent to their parents to stay in the home, then the parents can do what they'd like and they could save it perhaps in that third party trust. So it's just a tricky piece, but absolutely there are different mechanisms and they really should just make sure they're not violating any of the rules because obviously $2,000 is such a low threshold. And so there's all sorts of things we want to save money for, but we just need to save it in the right spot depending on who it belongs to.
Yeah, I was thinking more of children that are under 21 where the parent is just saying, we just want to save X amount of dollars every month so that if something comes up after she turns 21, there'll be like a safety net that's not going to affect her SSI. So I guess they would need to do the ABLE account or would they need to, okay.
Yeah, so 21 for SSI is not going to matter. The age piece there is when somebody is applying for SSI, if they're under 18, then their parents' financial resources are also going to impact their ability to receive SSI. So sometimes if parents have, well-paying jobs and resources, the child's not receiving SSI. But once they turn 18, individuals' parental or household income and assets isn't going to impact that. So once they're 18, then it's just that beneficiary's financial resources. And so absolutely, it makes a ton of sense, but ABLE account's going to be a good way to do it in the terms of saving that money directly that belongs to the beneficiary. Or if that parent is just saving money for their child, third party trust is ideal.
Okay, great.
Yeah.
I also had a question of, so on your last slide, you talked about in-kind support. So let's just say, for the sake of a argument, grandma left money to Adam and she stipulates in the trust of once a year going to Disneyland or Disney World.
Okay.
That would go in the letter of intent, or because it's part of a term of the trust, it sounds like, but that could be kind of
That's a great, yeah,
support.
that's a great, no, so maybe, right? That's the lawyer answer. um, no, so two different things. So first of all, let me further clarify a letter of intent. So the terms of the trust are going to be what direct and are mandatory terms for the trustee to follow. And typically things like Disneyland annually is not going to be in the terms of the trust. You're right. That's more commonly in the letter of intent, which is evidence and could be used, but it's legal in that way, but it's not necessarily in the terms of the trust. So that if it's COVID and the beneficiary can't go to Disneyland that year, the trustee is not violating its job. But the letter of intent is really evidence that, you know, as long as the money is there and it's sustainable, that can be made. That's a little bit different than in-kind support and maintenance. In-kind support and maintenance is, again, if the beneficiary is on SSI, if the trust is making distributions for food or shelter. And so in a trustee, or excuse me, in the example of Disneyland, the only piece that gets a little tricky is hotels, but typically that's not an issue. But typically we're just thinking about, hey, if the trust is paying the rent of the person, well, then their SSI benefit is going to be reduced by a third. If they're paying for food, for example, they would reduce it by a third. It's very tricky, but Disneyland is not in-kind support and maintenance in and of itself. Does that make sense?
Clear as mud, but yeah.
That's the problem, right? But yeah, there's so many different factors, but taking vacations, education stuff, all types of distributions that are medical, for example, are not going to reduce the SSI. Food and shelter distributions could reduce the SSI, but things like Disneyland tickets, damage, theater shows, that kind of thing are not going to impact that. Any other questions or further clarifications?
No, thank you very much. That does help, because the verbiage is, I mean, it's kind of, yeah. I think of in-kind as like, oh, I don't know, baking some cookies and, you know, them letting you borrow their oven. So
I understand. Yeah. That us silly lawyers and government agencies use these terminologies in so many different ways that it's hard to, I do understand what you mean, right? Because if you're making an in-kind distribution of a trust asset, that might mean you're distributing a necklace or a autographed baseball. But in this case, in-kind support and maintenance is very specific terminology applied to SSI benefits that are very tricky.
And if just my one last question, in an ABLE account, I just thought about this. In an ABLE account, can you can do that at like any bank and have it named an ABLE account, or does it have to go through something very specific?
Very specific. So ABLE accounts, I think every state now has an agreement. And so what I'd recommend you do is, I don't remember the specific website, but I'll send it out in the email. There's a national ABLE resource website that's great. And you can only have one ABLE account and you need to set it up in a certain state's program. So every state has one. And if you go to this national resource center for ABLE accounts, you can kind of compare. But no, ABLE accounts are managed and authorized very specifically. So ABLE accounts, typically you join a state and they have a program. And so they're pretty inexpensive to set up and pretty easy to administer, but ABLE accounts do, some states can make a claim on the ABLE account assets at the termination of an ABLE account as well. So there's a lot of rules on ABLE accounts, just like there's a lot of rules on everything. But there's great resources to learn more online, and I'll share some of those with you.
That is great. Thank you for answering my questions.
Absolutely. Thanks for asking them. Okay, we got a few more here. Anita, you have a question.
Yes. Hi, Emily. My son is 24 and his dad and I are in our 60s, and our relatives are mostly older as we are. And so for his trust, I currently have my sister named and his father named as trustees, but have been thinking, and especially after everything you've presented, that may not be the best choice, given that we're all so much older. And there aren't really options for someone younger, either friend or family. So what do we do?
Yeah, that tends to be when we're looking at a professional, whether that's a corporate trust or a licensed fiduciary. So it'll depend on your circumstances, but I would definitely recommend considering talking to a professional. So a licensed fiduciary in the state of Arizona, we have a licensed fiduciary program, which allows individuals and small companies to be licensed by the state of Arizona to serve in the role of trustee, guardian, et cetera, and they can serve. I'm happy to send you a chat with you about that, and we can talk about who might be a good fit, but that'd be a good place to start. Also, in some circumstances, smaller trust companies are great at special needs trusts. It's hard to go to some of the big national banks and corporate trustees because they tend to have very high dollar amount thresholds, which at least myself personally, my trust would not qualify for. And some of them do not administer special needs trusts. So you want to interview a couple professionals that that really, again, understand this piece, but special needs trusts, as you learned today, are just their own nature. And so we want to make sure. So I'll include on my follow-up email a list of some that I know in Arizona can serve as a trustee of a special needs trust. I'd be happy to talk to you about all of those different pieces, but it sounds like you're right. We want to make sure that the trust document has sustainability. It may be that if something happened to you, your husband, or I'm sorry, the beneficiary's father could serve for a period of time, but even in that case, they probably would not serve through termination. And so we need to just have sustainability and kind of backups in that piece. So is that helpful, or do you have any more specific questions about the different types of professionals?
No, that would be great if you could send that information. And then I have another clarifying question regarding the SSI and SSDI with the in-kind support and maintenance. What you were talking about with SSI in that regard, that does not apply if they have SSDI, is that right?
That's correct. Of course, the attorney in me wants to say in a few circumstances, some people will have a portion of SSDI and a portion of SSI. So you just need to be careful, but SSDI correct, as well as disabled adult child benefits. So in this case, if you were to pass away and your son were to change the nature of his Social Security from SSI to disabled adult child benefits, that also is not impacted in that way.
Okay, we've applied for him. He's been denied 3 times. Well, twice. We had a hearing. We're waiting for the results. So we're hoping that he gets the disabled adult child.
Oh boy. Yeah. Sorry about that. And I think, I'm not a Social Security attorney per se, but there are some good ones if you don't.
No, we do have one who actually you recommended.
Okay, good. Well, I'm going to send some positive thoughts that goes the right way then.
Okay, thank you.
You're welcome. Any other questions? Those are some great questions, and I hate to take it so lightly, but there's so many things we can talk about. And my goal today was just to really make sure that we've got in place enough structure and breakdown in terms of the role, so you can understand the importance, whether you're taking on the role of trustee or you're appointing somebody. It's a big job. And most importantly, I think getting the resources put in place so that the right people are stepping in at the right times. So I'd encourage you to look at that. I thank you guys for participating and sticking around during all of this. I'm happy to keep sharing information. And of course, if you're here in Arizona and and want to talk about your situation, give me a call or shoot me an email, and we'll get something set up so we can either reevaluate the current trust plan you have in place, or looking at things in more detail if you don't have one yet. And like I said, we'll follow up. There will be some show notes if you're watching this recorded, or if it's live, I'll follow up with an email. But I hope you all have a wonderful rest of your weekend, and please don't hesitate to reach out if you need anything. Talk to you soon. Bye-bye.